During the break, I was able to confirm that the final EIS does not have any appendices, but there is a summary, which I don't think is part of that.
Okay. That is Exhibit T that you handed me, is that right? Rand Ridge.
Yes.
Impact statement.
Mm-hmm.
FES had no appendices. There was a summary, but that's not included. Is that accurate?
That's what I was told, yes.
That said, we are gonna go back on the record. Sloman was just explaining a fine point of an exhibit, Exhibit T, that was submitted, noting that she confirmed there were no appendices to that original document. There was a summary, which is not included. As far as I'm aware, I have all the information I would need related to any finding on SEBA. So I think with that, we will turn it back to Mr. Snyder and the applicant for their next witness. Is that accurate?
Yes, thank you. We have Mark Vildee, who is the civil engineer for the project. If I could pass out his CV. As
Letter X, I believe we are at. Thank you.
And just by way of introduction, Mr. Vildee has up there poster boards which are blow-ups of some of the plan sets that were submitted in March of 2019. It's portions of Exhibit B62 to the staff report.
Okay.
And they should be identical, they're just blow-ups.
Okay.
Yep.
Great. So I'll go ahead and get Mr. Vildee sworn in. Do you swear affirm to tell the truth in any testimony you give here today? Thank you for being here.
So, my name is Mark Vildee, civil engineer licensed in the state of Washington, principal at KPFF Consulting Engineers, 36 years experience. It's kind of work. So what I wanted to do was talk about the Plat infrastructure, to talk a little detail of what is the infrastructure that's being proposed for the Plat. So again, these are directly from the Plat drawings. This is the civil engineering side of the Plat drawing. So Core Design did the survey. KPFF did water, sewer, storm. There you go. So using this sheet as a summary sheet, I'm going to walk through very briefly. And previous presentations have got there the street and access improvements, the utility improvements, and drainage improvements. From a street and access standpoint, as was described, we have many existing streets full of utilities surrounding our site. They're either existing or they're in construction adjacent to us. So we're in a situation to plug into this infrastructure. The construction related to this plat will be the extension of Northeast Federal Drive and the extension of 8th Avenue down here. Both of these are sub-collector ones, and both of these are sub-collector ones per an AMM. And I should.
Would you explain to us what an AMM is, please?
It's a administrative minor modification that's been issued after the overall permits. So it's an evolution of the permit, I guess is what I would say. Let me get the number. Subcollector 1 is AMM 16-00002. This is a street classification and a street section that has been implemented throughout the area adjacent to us, so it's consistent with that. So, and then beyond these two new street legs, you heard before, we have half-street frontage improvement requirements along Discovery Drive, and those will be constructed as well. Beyond that, the perimeter infrastructure will provide access to lots in the future. So that's streets and access, utilities, if I talk water and sewer, broadly speaking, in every frontage street that we have. And so they are there for servicing the development. Whenever we construct a new street, we'll extend the water main to tie the water main grid together. And we do have some sanitary sewer extensions to come up to serve future building uses. Same is true down on 8th Avenue, and there is a sewer extension proposed down in Discovery Drive. And I'll show a little more detail on that. And I think the more interesting perhaps, or more complex, is the storm drainage system out on Issaquah Islands. And I'll say this, we're not at the downstream end of the system, but we are towards the downstream end of the system. And so there are some large diameter trunk lines in Discovery and in Ellis Drive that are communicating drainage from above us, down and past us. And we will fundamentally be making connection to those mains. There are two systems that have different requirements of us. There is something called the bypass system. And I would defer to Doug as to why it's called the bypass system, but I believe it's the bypass system because it bypasses Reed Pond. And so these are trunk lines that come down, combine, and then discharge, bypassing Reed Pond. So, big pipe. Our development, the Plat, has to discharge the bypass system. So talk about the on-site component of the Plat, that has to discharge the bypass. And with that requirement comes performance detention requirements. We're allowed 1.43 CFS release during a 100-year storm event from the collective Plat to that point. And so what that does is that requires of us storm detention, and then not due to that, but we're also required to provide water quality for all that. So area of the Plat will go to the bypass system, and our options are surprisingly limited. So I told you we have a bypass line here. We're gonna make connection right here to the existing bypass line and get all this flow back into that system. So all of this comes back and discharges at that point. And then we have a bypass line down in Discovery, and so these lower line blocks need to turn around and find their way into that main. I mentioned the 1.43 CFS allocation to the site originates from a December 1, 2016 memo, development entitlement for Issaquah Islands Investment Fund LLC. And I don't know if this has been entered into the record, but I do have copies.
Why don't we offer this as an exhibit?
Okay, so this would be what again? This is a memorandum
Of entitlement.
of entitlement.
There's three.
It's from Ms. Sloman, and it's, I think it'll be Exhibit Y.
It would be, and has the city seen this? Just want to give the city an opportunity to review this and see if it tracks with what the city.
May I ask a clarifying question?
Certainly.
So I've just now seen this document. It looks as if the signature page, page 6, has signatory lines for city representative, which has been added. It looks like there's at least a stamped signature. And then there are also signatory lines for Mr. Abelmore, the authorized agent for Polygon, and then Gary Young, the authorized agent for Shelter Holdings. Is there a version of this document that includes signatures other than the city? Do we know?
I do not have a copy of that.
To the best of your knowledge, does such a document exist? You just don't happen to have it with you?
That memo is a version of a memo that Ms. Sloman would write periodically over time. We were never asked to sign it other than this version. There were mistakes in the portion not related to the stormwater, related to the entitlement allocations, and I sent comments back to Ms. Sloman, to which she never responded. So we did not sign off on it. I don't know whether Polygon did, but it's really just a memo from the city, so it was never clear why they were asking for a signature to begin with.
Okay, so just to be clear on the purpose for which this is being proposed and admitted would be, this is the applicants showing why they believe they have an entitlement to 1.43 CFS for stormwater purposes. Is that accurate? Is that number track with what the city believes? Can I admit it for that sole purpose?
Yes, because the 1.43 CFS is in our staff report.
Okay, so was there some other reason you were hoping this
Nope.
comes in?
Well,
Okay, go ahead.
Only because Doug made an earlier statement about capacity concerns, and I didn't know where that was coming from. So I wanted to go on the record or be transparent as to this is our understanding of our discharge.
Okay, so I believe then I'll admit this as Exhibit Y with the caveat that the purpose of this is to, and is there an exact spot on here I should really be paying attention to that shows me that number?
Page 5.
Page 5.
Top of page 5.
Okay. If I add all that up, do I get 1.43? Or no, it's the lot B north is this lot. Is that accurate?
Yes, we were.
Okay, so really the function of this is this table 4 on page 5 shows the allocation related to stormwater for this particular property.
Yes.
Accurate, everybody?
And I'm going to speak to the next section too.
Okay, well, we'll cross.
That'll come
I'll
up
give the
right
city
now.
a chance after you speak to the next section. but-
I'll go there right now.
Okay.
So I'm still in the bypass drainage basin, and this memo identifies a alternative to purchase capacity within the city's downstream system that we understand per the memo has been extended to the applicant as an option. It's not embedded within our plat right now because we were showing detention and water quality facilities for the infrastructure. But I feel that this is worthy of clarification if that interpretation is not correct. Basically a fee in lieu of provision for the bypass.
Okay, so the applicant is essentially saying it's their understanding that they have two options. Option 1 is they, through a system of stormwater ponds or something, you're gonna capture and treat stormwater before it hits the bypass system. That's option 1. The other option is to pay a fee in lieu of that, and the water goes straight into the system. Is that?
We would still need water quality.
You would need water quality, but you wouldn't need detention
For what is paid.
for what is paid. Okay. Does this track with the city's idea?
Yeah.
No. Okay, so there's a dispute as to this. Okay, and is this dispute then somehow related to vesting or?
We feel this is outside of the plat. That was never co-signed. When we worked with other applicants who were interested, such as Polygon, there was a separate negotiation outside of this memo because it was never executed.
Okay, so the city is of the opinion that what was proposed in this the memorandum, was never agreed to. There was no meeting of the minds of the party, and that isn't sort of on the table at the moment, or it's something that would have to be negotiated separately in some other form, some
Right,
other
it wouldn't be through the
document.
plat. There would need to be additional analysis. I mean, that's 3+ years old.
Well, is that part of the issue, is the numbers are no longer up to date with what these things would cost? I mean, is that,
That's a possibility.
that's a possibility? Okay,
And whether there still remains capacity.
okay,
And I'm not sure that we would agree that there is no detention.
okay. Ms. Schneider, do you want to speak to this issue, or at the moment, or do we want to?
I don't feel any compulsion to speak to it at the moment.
Okay. Then I think I at least understand the city's view, but I have the memorandum. Everyone, did you have something, Mr. Law?
Very briefly, Mr. Examiner, the city will be prepared to address this on rebuttal once we've heard
Right.
the applicant witness's testimony, and to the extent that there is a dispute, I think we can flesh it out through our rebuttal.
Okay, great. Well, then I'll quit interrupting and let you continue.
Okay, so I'm still on the bypass system. The plat needs to discharge the bypass system. And within the plat drawings, we articulate conceptual locations for detention and water quality for this roadway. And we do the same for this roadway down here. So then if I can turn to the other drainage system, which is the Reed Pond drainage system. Reed Pond being located right here. We articulated in our documents, drainage reports, and narrative, that our discharge from Discovery Drive right away can discharge to Reed Pond, has to discharge to Reed Pond, not the bypass system, undetained and without water quality. I have an email from Dan Urban that I don't know if it's been entered or not, that says that outright. And it's our understanding that both detention and water quality has been provided for this right-of-way downstream. So I bring that up because I think there was some comment from you concerning that. And if this needs clarification, then it's the avenue to do that. And as you look at our plat drawings, therefore, you'll see no water quality, additional water quality or detention provided for Discovery Drive. So that's my overview. And what I'm gonna do now is I'm gonna go block by block. And this will be quick. It sounds long and laborious, but I'm gonna go around like this and flush out a little bit more detail of what this means. So starting block A, and that would be the same configuration. Block A, from a straight standpoint, here's our sub-collector one that's will be constructed, single lane each direction, consistent with the AMNs and other streets in the area. Connecting the grid, signalized, and we'll have 3 lanes at that end. Beyond that, from a street standpoint, there's access available around the rest of the frontage streets. Utilities available, other frontage streets. We will extend a water main to connect the grid. We'll extend a sewer to pick up future Block A and Block B flow. And then detention is, again, a little more nuanced. Block A needs to get to the bypass system. Block A needs to get down to the bypass system. So we are proposing in the plat a dedicated storm drain that once it's detained and cleaned, will run down to the bypass system. And then I mentioned before, for the new street, we're going to provide detention and water quality in a combined system with Block B system.
Would you, Mr. Veldy, identify each plan sheet
Oh, I'm
by
sorry.
number as you begin to talk about it? And the one you just talked about was, I think, 102 maybe?
First one was C-101. And then C-201 was the second one. And now I'm moving to C-202. So we talked about federal relative to streets and access. We have a new sub-collector one to construct down here, 8th Avenue, to connect Deer Lane to Discovery Drive. Again, sub-collector one, similar section to over here. Interesting for a civil engineer is there's some grade that has to be taken out between those two locations, so the street becomes steeper than one might think. And then beyond that, because of all the infrastructure around us, we have many locations to provide access to the parcels. Utilities, again, utilities all around us. We will be extending water main in the street again to connect the city grid. And we have need for a sewer extension to get us out to discharge to Discovery Drive. We also have need to communicate this drainage, which is too low to get to the bypass system here, to communicate to the bypass system out in Discovery Drive. So you start to see some storm drain connections from Block C and Block D getting into the bypass system.
But there's treatment as well.
Treatment, all of this detained and treated.
Okay.
Yep. So I think that's it for that sheet. Maybe one more sheet, which is C-203. Speaking about the streets, this is our street that we're doing half-street improvements on. We're doing improvements on the entire frontage from 9th Avenue down to the end of the property. Improvements basically creating a more formal edge than exists there today. Sidewalk the entire way, bike lane that's been referenced that will tie into a multi-purpose trail at the south end. And then channelization that really responds to Mike's analysis. So Mike classifies the road, and we mentioned different classifications as we go. Mike provides channelization requirements, if you will, relative to turn lanes. Where do we need them? How long should they be? At a Plat level, we put that together with the road design standards and the city input, and we're left with a conceptual for the road. There was a discussion about neighborhood collector in 1 or 2. And on our plans, we've articulated a neighborhood collector 2 that comes out of an AMM that was provided. I'd like to give a number for it. It is AM 11-00005. And what this classification does is incorporates bike lanes on both sides of the street. For us, it gives us vehicular access to this block down here, because AMN for Neighborhood Collector 2 gives you the opportunity to have direct access. And it gives the opportunity to have parallel parking or one or both sides of the street. So that's the reason it was proposed as a neighborhood, not a one.
The difference, I didn't
Difference
fully
is-
get, so.
Okay.
With 1, you're saying, sorry, with 2, what you have proposed, you're saying it allows direct vehicle access, bike lanes, and parallel parking on at least one side.
Correct.
But with neighborhood 1, you don't get those things?
Correct. I don't believe you get vehicle access unless you have a turnaround proximate. I'm getting out over my skis a little bit on that,
Okay.
but that's the rationale, our need and the rationale for what drove it to.
Okay, and then the reference, you said AM 11000005. This was a document that, or a decision, I guess an administrative decision related to this proposal that was provided to the applicant during the course of.
This was a determination made in 2011 and documented. It was one of the AMMs provided to the design team as, hey, these might be relevant to your application.
Okay.
And so we sought that one out for its relevance.
Great, sorry to interrupt, thank you.
Sorry, street. Okay, so I got the street covered. Utility systems, there's an existing water main in the street that will be used for extension. There was a comment about the sanitary sewer separation, I think, came from Doug. We're proposing a sewer line extension in Discovery Drive right now, based on the strength of early discussions with Dan Irvin and Doug, that may be an easier route than making connection to the deep cased sewers. We have a sewer in the street, it's deep, it has limited manholes. We can get into that, or we can do this. And so I think this is a design detail. Right now, we've erred on the side of, we'll show and we'll propose a sanitary sewer extension. It may be possible in the future to get into the manholes of the existing main. That's utility, and then circling back on drainage, we believe no detention is required. We believe water quality is not required for discharge to Reed Pond. And so then what you see, if you look closely, what we have to do is then go pick up all the drainage that's out on the street right now on the south side, and then convey it into a new conveyance line, make sure that all gets to Reed Pond. So another storm drain for Discovery Drive, some more connections down here. So it becomes kind of a conveyance point issue for us.
Okay, so none of the stormwater that would be generated from blocks C, D, or E would in any way be conveyed to Reed Pond. It's just the stormwater from Northeast Discovery that would be collected and conveyed to Reed Pond without treatment.
And I guess the last comment, there are a lot of utilities in Discovery Drive. There's a lot of big utilities, deep utilities, at least 3 storm line systems that I'm aware of right now, water main. And so it's an engineer's challenge to fit things through there. And in my opinion, to do a level of planning right now to prove to ourselves that we can fit things. So I think we've done that, but we have design yet to come. So I think that's what I wanted to cover.
Okay, Mr. Schneider, do you have some questions?
Just a handful. So, Mr. Valdez, the plan set C203 that shows what we're calling road segments on Discovery Drive and the Neighborhood Collector 2, has that been in this plan set since March of 2019?
Yes.
Okay. So, how many plat applications in ballpark numbers have you been the civil engineer for? And what's your opinion? Well, first of all, we've heard comments this morning that there's too much detail in this plan set. Had you ever heard that previously?
This is preliminary stuff.
What communications do you recall back and forth with the city about the level of detail the city was asking for?
This is the question.
We received comment to add dry utilities to our plan set.
The approval to the city.
What are dry utilities?
And those are electrical, they're telecommunication. And at that time, we pushed back and said, yeah, we don't think so. It's necessary, and the city agreed with that. So, but if I could expand a little bit, and then you'll ask me to keep me on track. I think the best planning is planning that can prove to somebody that something works, and it works in 3D. Yeah, we're supposed to work in 2D, but I believe Doug can look at our plans right now and say, yeah, it's gonna work in a third dimension. And it's not that we've gone overboard, but we needed to satisfy ourselves that we knew how to get storm drainage from Block A back to the bypass system. We needed to satisfy ourselves that we could fit everything down through Discovery. And so in 36 years, I've never been accused of taking something too far. And not that I'm accused, but I think it's appropriate. And I think one can look at it and say, yeah, it works, and I understand exactly how it works. That's my opinion.
We've heard several references to Mr., is it Irvin?
Yep, Jan Urban.
What's your understanding of his position with the city?
My understanding is he was a consultant to the city, acting as a project consultant on behalf of the city. I think in the same capacity that I believe Doug is.
Was it possible for you to design the street system before you received those AMMs from the city?
I don't recall the dates of when we got the various AMMs. The Federal Drive, when it was originally designed, didn't have the benefit of the Subcollector 1 AMM, or I would hope we would not have done that. That being said, it was only a couple dimensions that were different. It wasn't a substantially different thing. But so, have I answered your question?
Well, we're going to hear some testimony from Ms. Heim about waiting for those AMMs. And so I'm just trying to have you explain a little bit more, in a little bit more detail, what role they played and needed to play in your preparation of these plans.
Okay. So the Subcollector 1 roads here and here.
You need to point towards the hearing examiner.
Oh, I'm sorry.
It's okay.
Benefited from an AMM that we didn't have a copy of.
And could you say that again, because I'm not sure he could see it when you were.
So these two roadways benefited from an AMM for a Subcollector 1 that defines the
Sure.
possible street section.
And can someone, and perhaps you are the correct person for this, I want to make sure I fully grasp the process. Are AMMs specific to a proposal, or are there a general interpretation of the code, or in this case, I guess, a development agreement that is that applicable throughout an entire, area that is governed by a development agreement? I'm just trying to grasp, because there was just reference earlier to a 2011 AMM, which clearly this project didn't exist in 2011. So what is your understanding of how these AMMs work?
My understanding is some AMMs are project specific.
Okay.
And if they're project specific, they'll say so. Some AMMs are broadly applicable.
Okay.
And can be used as reference.
Okay, so then for this, the AMMs you referenced, are they of the more broadly applicable variety, or some are and some are specific?
My interpretation from the AMMs was they were applicable and could be applied. And part of that also comes from the fact that they were provided by the city to us as potentially applicable.
Okay, so your understanding was past, these are administrative minor modifications, do I have that right? Is that the right acronym?
So,
Yes.
Yep.
Okay, your interpretation was that past AMMs, and again, are these related to the development agreement as opposed to any kind of portion of the code, municipal code?
There's a different procedure in the IMC then, so AMMs are development
I
agreements.
thought so, okay. So your interpretation was these past AMMs related to the development agreement were of a general nature and could and should be applicable to your, is that accurate?
Yep.
Okay. Sorry to interrupt your questioning, Mr. Schneider. I think I get it, so if you have further questions, please proceed.
And we have an email when the city sent those to us that we'll be introducing.
Okay.
I believe has them as attachments. So I just want, you may have said this and I didn't hear it, but can you explain a little bit why these trunk lines are called bypasses? Why are they bypasses as opposed to something else?
And I'll start my answer, well, I'll just say, my understanding from interacting with Dan Urban and with Doug is that these are essentially bypassing Reed Pond. And bypassing Reed Pond.
And what is Reed Pond? And how do you spell Reed?
Or R-E-I-D. And Reed Pond is one of the...
Put it on the easel, please, so the hearing
Sorry.
can see.
Sorry. Okay, Reed Pond is located right about here. It's one of the regional stormwater facilities that has been constructed. I don't know when it was constructed, but it's providing stormwater function for a broad area of Issaquah Highlands.
So the trunk lines, they are trunk lines, they just don't go to that regional system.
The bypass system does not go to that.
And is any portion of the project, as you've designed it, going to Reed Pond?
Yes, Discovery Drive.
Okay. And why that distinction?
That distinction was made to us by Dan Urban. Dan said, your site's going to bypass and Discovery's going to Reed. And that's it. And my understanding is that's based on the historical modeling that's been done and the allocation of flows to different systems.
If the city now provides, we've had a discussion with the hearing examiner about preparing a new plan set. If the city gives us comments about where they think there's too much detail, what would that entail, and how long would it take for your firm to prepare a new plan set in response to the city marking up the existing plan set?
I can't answer that until I know what changes we're talking about. And in candor, part of the issue that we have is staffing and who's going to be in our office relative to the virus that's happening. If you were to give us a markup, let me say it another way. If you were to give us a markup by Wednesday, say, take these things out. LD, take the water meters out, take these lights out. we can do that with time and personnel. In a normal situation, we turn that around within a week, and that would be our goal.
But you're not sure because of the COVID virus, coronavirus, whether you're gonna have the staff to turn it around in a week?
Yeah, for us, it relates to working from home, and our CAD techs working from home, and do they have the ability to work CAD from home or not? And this is a topical issue right now that's being discussed in the office right now. So it'll.
And since you submitted the plans that we've been talking about in March of 2019, have you received any feedback of any kind from the city on the plans? I think that's all I have.
Okay. Mr. Lell, did you have questions?
Just very briefly, thank you, Mr. Examiner. Mr. Velde, if I could ask you a question regarding the memorandum, I think you referred to it, from Mr. Irvin, Dan Irvin. Do you have a copy of that document?
I do.
Didn't we pass it out?
Did you? I mean, is it?
Is that the one we just, where did I put it?
That was the email.
So maybe I didn't just receive it. The last document I've got was the memorandum from Ms. Sloman.
Exhibit Y?
That's, yes, Y is the last one that I've
That's the
received.
last one I have too, I believe.
We have it, Ms. Hyman informs me, in the documents we're gonna offer. If it's important, we'll find it.
It isn't. I just want to make sure that it's documented in the record. I think that there might be some disagreement regarding content or intent, and I think it'll be very helpful if we actually have the written record, and it sounds like we will eventually.
Okay.
Thank you. Clarifying question with respect to your professional expectation in the level of design that's been shown on the plat or with the plat and the plan set that we're talking about today, as it relates to the utility infrastructure. In your view or your expectation, is additional design going to be required at future stages of
Yes.
project development?
Yep, you bet.
Could you expound on that in terms of the nature and extent of that additional design?
Certainly. I think if you look at our drawings right now, you don't see many numbers on them. And so everything will need to be defined vertically with an elevation or with a road profile that you can track. So that'll come. And what I'm very pleased about the plan set right now is we have profiles. We have profiles on there. So you can look at them graphically, and Doug can say, yeah, it'll work. I don't have to tell you what the number is. You can look at the profile and say, yep, you can get to that detention vault, and your pipe that's receiving it is below it. You know, it works. So I'm going long-winded on you, but you'll see a bunch of elevations. You'll see details. You'll see construction details. There's no construction details in the set right now. Details on detention vaults, flow control, risers, you name it.
And at what level of project review do you anticipate or contemplate that additional level of detail will be provided?
That should come in with our first site work permit. You know, the first construction permit that we do for any of these improvements need to have elevation control on them, because that's the point in time that the reviewers are looking hard for that.
Just to clarify, that wouldn't occur at the final plat stage. It would be actually site development, future building permit stage? Or-
Building permit or site permit. Whenever we come in for a construction permit, we have to have that information.
Thank you. And finally, this is going back to your communications with or from and to Mr. Urban. You alluded to some direction from him or a communication, as I understood it, that differentiated for the outflow path for stormwater for the rest of the property on one hand versus Discovery Drive on the other. Do you recall that? Was that oral direction, or was that also in the email or memorandum that Mr. Schneider is going to be producing into the record?
I don't know the answer to that.
Do you recall the time frame that that communication occurred?
I was having communication with Dan and Doug throughout. I think we started in 16 and continued it through 17, really. This is the,
I found an email that may be the one.
It's hard because there's no color there, and so that's, you see how he
Yeah.
responded within the text to
yeah.
you?
This is the detention will not be required
Yeah.
for Discovery Drive. So it was a continuum, and I do have emails that I haven't entered in, and I did have direct conversations with the gentleman.
And that, I'm sorry, that Tim,
And if I could, and say this, it's a surprisingly complex system that's out there. In Dan Urban and then in Doug Schlepp, I had access to people that had history with the system. And that's what I was doing, was reaching out to try to tap that history to be able to pull response and Plat together.
thank you, no further questions.
Any redirect based on that? Mr. Chairman?
No.
So I guess one question I had, because KPFF did prepare several sets of documents, but the August 28th submittal, which we heard testimony earlier, was intended to be submitted August 1st, and there were computer issues. Nowhere from my review, nowhere in those plans that KPFF prepared did we have sort of this level of detail of building footprints and parking. So that came with this plan submittal, is that accurate?
Yes.
And was there any particular reason?
Oh, this was
KPFF
submitted, can somebody help? This was submitted after
December.
the initial August Plat submittal. This was submitted, you're saying, in December of 17.
Right.
Yeah, supplemental.
But the building footprints and the parking and that all was important to add for engineering considerations related to, in your view, to how stormwater traffic, the things your firm was responsible for, put those in because it was important to include those? I'm just trying to understand where we got there.
Yeah, we have a note on the drawing that speaks to buildings being shown to articulate rationale for some unusual property lines.
Okay.
And then for us as a civil engineer, when I'm articulating my sewer extensions to come up to serve the lots, I need to kind of know where I'm going.
Where things are.
Yeah, and so this, if nothing else, provides me the targets, and if one were to look at the plat drawing, you know, I think those targets that are insinuated by these building locations have been satisfied by what we're showing here.
Okay. Thank you. Does that then conclude testimony of this witness, Mr. Schroeder?
If I could just follow up on that.
I'll let you follow up.
So, in terms of your submittals to the city for this plat application, how did they evolve? What is in the March 2019 submittal that wasn't in the December 2017?
Curb bulbs, in response to city comment. Doug asked us to, or required us to move vaults out of city right of way that we moved from the first set into this set. We modified Federal Drive because, as was noted, it's dimensionally too large and inconsistent with AMM, so we modified that. We modified Discovery Drive in response to review comments from the city, but probably more fundamentally Mike's traffic analysis that define turning functions and then marrying in road standards with the classifications that he came up with. So those are the big changes, and we really didn't have all that many changes to the plat beyond that.
So any changes that you can recall, just to bring this to the conclusion, that weren't either in response to a city comment or in response to Mike Swinson's traffic analysis?
Oh, I assume some of my utility servicing was changed based on this. So I haven't compared, but it wouldn't surprise me that that's the case. We received a comment during Block D review that pertained to making sure that we had fire access around the entire building. And I think with our first submittal, we weren't satisfying a 20-foot clear in Discovery. And so that changed some of the Discovery configuration that's reflected on the plat.
Thank you.
Does that then conclude testimony? Any further based on that? No?
We don't have anything further at this point.
Okay. Thank you, Mr. Beldy. And Ms. Heim, your last witness? Then?
Yes.
Great. Okay. I know you spoke earlier, and I didn't have you on the record, but I think it was just clarification. But I'll get you sworn in. You swear affirm to tell the truth in any testimony you give here today.
I do.
We know you to be an upstanding, upright person, so that helps.
Ms. Heim, while I'm finding the first exhibit, would you explain to us, please, your role with Shelter and with this application?
Yes. So my role with Shelter is that I am part of the development team. My background is as a land use and real estate attorney. Sort of transitioned from a traditional practice into the development side of things a long time ago now, 13 years ago probably. I worked for D.R. Horton for a long time, running their entitlement department, so oversaw thousands of lots being created through plats in that role. At Shelter, I work on the entitlement side of things, some construction issues and some legal issues. On this particular plat, I was really the point person that was sort of project managing the application.
I'm going to be handing out a proposed exhibit. Can you explain to us what this is and how it was prepared, please?
Yes. So this is something that I put together to outline the plat review dates and timelines. There's two parts to it. The first page, I tried to go through and break down where the various points of review happened as far as when we were waiting for the city, when the city was waiting for us, to show how that time is allocated between the two. The second page through the final page really just tries to be an accurate chronology of the dates and times that things happened that are relevant to this plat application. So, do you want me to start walking through this?
Well, let's get it marked. And
So, my question, Ms. Schneider, there's several, I see stacks of papers over there. Are we gonna have several things that you're hoping to admit at this point?
yes.
Would it be easier to call them Exhibit Z and then sub-label them one on down, or do you want to do Z, AA, BB? Is there a preference?
From the city standpoint, I don't think we have a preference except to say that they should be individually labeled, and I would have to defer to staff as to whether or not there is a kind of a uniform historical approach here that we could follow. Does it make sense to double Z, double A after we reach the?
Sure. The reason we didn't use numbers is if this is appealed to city council, then the exhibits get numbers. And
okay.
then it becomes very difficult to know whether you're inside of an exhibit or not. I
Okay.
don't think we appreciated that we would be past.
Okay, so why don't we then, just to be safe, why don't we make this Z, and then at this point forward, we'll go AA, BB, CC, as far as we need to. So this will be Z, Exhibit Z. Does that track with what everyone has? Okay, great.
So, Ms. Hyman, before you explain the content of this, is this done from memory? Is this done from review of documents? How accurate is this?
Oh, this is done from review of documents and emails and meeting notes. So I would say it should be very accurate.
Okay. And well, why don't you go ahead and talk through this document, and then I'll ask questions when you're done. Explain what it is that this tells us about the process.
Okay, so this first page, it actually starts with the submittal of the complete application for preliminary plat. So it does not go into detail about all of the pre-process that the city imposed on this application, even though that pre-process wasn't part of the code. They did require it, and we did go through it. So this picks up from August 1st, 2017, when we submitted our complete application. And the first period of time that it outlines is from then to March 16th, 2018, which was the point at which we got our first set of plat comments on the plat application. You will recall that there was reference to some comments that were given on the transportation analysis that happened in January. Those were sort of independent of the rest of the plat review, so we couldn't do anything with just the transportation comments. We needed the full plat comments, and it took from August 1st, 2017 to March 16th, 2018 to accomplish that. Then when we got the comments, we looked at them, realized quickly that we needed to have a meeting with the city to understand some of them. And so the next period that you see is from that 3/17 to 3/29 of 2018, which is when we had the plat meeting with the city.
And before you go any further, I just want to be real clear for the record. A second ago, you had said the pre-submittal requirements that were not part of the code. Did you mean that were not part of the requirements under the development agreement?
Yes.
Okay.
Yes.
Sorry, just wanted to be clear about that. I'll let you keep going.
Okay, so then we had the meeting on March 29th, 2018. At that meeting, there were certain items that the city agreed to provide as follow-up, items that they either couldn't answer or didn't have with them in that meeting. We were waiting for those until April 18th, 2018, which is when we got those back. And so then you see we switched to the green color, and from April 19th to the 26th is when we were going through and trying to understand the new comments that we had received coming out of that meeting. We were actually quite confused by the comments that came out of the April 18th meeting, because many of them we did not believe were consistent with the markups that were on the plat. So on the 27th of April, we wrote an email back to the city asking for clarification on some of them, asking for legal basis for some of the comments, because they were asking for things that we couldn't find any basis in the applicable regulations, so in the development agreement or other applicable regulations. So from that date in late April, we were waiting for a response. There was much back and forth as far as, when are you going to respond? Oh, next week. When are you going to respond? Oh, maybe it's going to be the next week. Actually, it's going to be the end of the month. Finally, it was until August 24th of 2018 before we received the first city response to that April email. And just for your reference, that whole email back and forth chain is in the record. I think it's K5. K5, A, and B. So the A is the email back and forth, and the B is a document that Ms. Sloman was putting together that was tracking sort of a comment response between the city and the applicant. So on 8/24, we had received the first response. We spent some time really going through those and trying to figure out if we could make enough sense of the information that we had from the city to revise the application and resubmit it. We found that we could not, and there were still further clarifications that were needed. And so on October 11th or 10th, we wrote an email back to Ms. Sloman and her team requesting additional clarifications and basis for conditions. Again, then we waited for quite some time for a response, and we were in a spot where we really couldn't revise and resubmit the application until we got another response from them, which finally came through on December 21st, 2018. Once we received that information, we could really put our consultants to work revising, making the necessary revisions to the application and resubmitting it on, I'm realizing there's a typo in the line that says 12/22/18 through 3/5/19. The second box next to it says 3/5/18. That actually should be 3/5/19 to match the other date. So we resubmitted it on March 5th, 2019, so that is the plan set that is obviously before you that we are asking for approval of. After that, we never received any comments, we never received any feedback whatsoever until we were informed that there would be a community conference held for this. Well, I guess we were informed that the Plat process had changed in April, but the next relevant date to sort of the back and forth as far as waiting on the city or waiting on us was the community conference, which under the replacement regulations would apply to a Plat. And since the city was no longer honoring the vesting of the processing of our Plat, they had determined that the community conference would apply. I think it's worth pointing out that even under the replacement regulations, the community conference is supposed to happen at the time of complete application. So instead, in our case, it was happening years after the complete application, so the timing of it was a bit off even from what the replacement regulations would have required. Nonetheless, there was a community conference in August 15th of 2019. After the community conference, the staff, with input from us, prepares a community conference response memo, and then it comes to the hearing examiner. So from as soon as that community conference was held, we repeatedly asked for this hearing to be scheduled, and you can see that it's been many months since that happened, and we're not entirely sure why that is. So that is the first page. I don't know, do you want me to stop there and ask if you have questions, or if the examiner has questions?
Sure, and if there are questions, otherwise we'll move on and start.
I mean, I very much feel that what's going on is this is sort of preservation of issues for another forum, to the extent that I don't know quite how the timing in this would relate to my determination on whether a preliminary plat should be approved for purposes of what the criteria are. I mean, I feel like this is documenting the back and forth related to, other issues, but maybe I'm misunderstanding that.
Well, in large part, you're correct. It
Okay.
is making our record for the
Sure.
vesting issue.
Which I'm happy to let you do.
And we're trying to minimize that. We spent 10 months doing that in front of the
I know you
Development
did.
Commission. But I think it's also relevant to some of the more specific issues. For example, the statement that we heard this morning for the first time that there's too much detail. Well, it's taken it's taken a year to be told there's too much detail in the application. So I think that that kind of fact should weigh into the hearing examiner's consideration of whether there is too much detail. But it's primary, you're quite correct, it's primarily
Okay.
creating the record.
So, yeah, I don't have any specific questions on those aspects of things.
Then what I would propose we do is go through the additional exhibits. These are exhibits that Ms. Heim identified because of her familiarity with the record and her belief that they should be part of this complete story. If I may, just to be efficient, I'm going to stand and hand them out and ask questions while standing.
No problem from my end.
Can I make one additional point on this? The other thing that I think is relevant is in the staff report that we received prior to today, the staff was asking you to approve our August 2017 plan set.
Sorry, the staff report prior to today.
So
You
the
mean-
staff report with the conditions prior
Okay.
to the one that was revised, the revised condition today. They were asking you to approve our August 2017 plan set, which to our way of thinking was totally inappropriate, given that there had been years of work going back and forth that went into a March 2019 submittal. I think Mr. Schneider was trying to get Ms. Sloman to clarify, which said she was in fact asking you to approve, and it was less than clear to me from her answers that the city is in fact on board with getting your approval of the March 2019 plan set, which is the plan set that is current and responds to many of the conditions. So there are a number of conditions, which I'm sure we will go through at a later point, that are not applicable because they've already been addressed in the plan set. And so the way that this was all set up and provided to you, my opinion is that they are dragging you into a level of review that really isn't necessary, because we've already gone back and forth with the city and we've gotten to a point with a plan set that responds to their comments. So going back to putting conditions that are already reflected in the plans is unusual and I would say inappropriate.
Okay.
Assuming this is Exhibit AA.
Correct.
If you could explain to us what this is, please.
This is an email exchange between Christopher Wright, who works for the city, and Dave Caton, who works for CORE, who was at that point the contact person for our plat application. In this email chain, there is an email dated March 8th, 2017 from Dave to Christopher that just confirms that the city had denied our request to just go straight to pre-app meeting and schedule that meeting, and was instead imposing a requirement for a collaborative meeting. So you've got that in the March 8th email, and then they go on to working on scheduling the collaborative meeting.
I got an extra one.
I marked the next exhibit as BB. Can you tell us what that is?
Yes, this exhibit is a letter from Director Niven to Nick Abdelnour of Polygon. And this is a letter that summarizes the city's position on vesting under the development agreement when the development agreement terminates. And so this is totally inconsistent with what the city is now applying to our plats and our projects. But this is what we had back in 2017 when we started this plat application process. And so some of the language in our narrative and on our face of our plat comes from this letter, because this is what the city was telling us at the time. This is the discussion that we had in our pre-app meeting, which happened within a week of the date of this letter. So this accurately depicts what the city was telling us and other property owners at that time. They've since changed their position with respect to only our applications.
CC, I assume?
So what is Exhibit CC?
CC, is that what you have?
Yes.
Yep.
Yeah, okay.
Oh, this is an email chain between Jean Lynn, who was the original planner on our plat, and Dave Caton at Core. It has attached to it the preliminary plat pre-app review meeting notes, which I don't know if these are already in the record or not. I couldn't find them initially, but it may be that they are in there.
I do not know off the top of my head, but I sure further review the record will let me know whether or not they are, but I don't think the email chain is it?
The email chain is not.
Or just on But these are the notes that were prepared following that initial pre-app meeting on, and those notes were June 7th, is that right?
Yes.
Okay. Of 2017.
DD. Sorry, what was DD then?
This is.
D is in
D.
David, D, email from Sarah Beth Levine or Levine?
Sarah Beth Levine, and she works for Shelter Holdings. So she had gone up, this is sort of confirms what Eric was explaining previously. When Core went to upload the preliminary plat application into mybuildingpermit.com, they did not have, it's a system that has drop-down menus and titles that you have to choose from. It didn't have appropriate options for each of the things that were on the required submittal list, and so they instead said they uploaded everything that had an appropriate category. Everything else they had Sarah Beth from our office take into the city to try to submit hard copies. So this was the email from Sarah Beth explaining what happened when she came here to the city. They said that they couldn't accept the hard copies, but just go upload it and pick whatever's closest, and that the city would fix it later. So that just again goes back to explaining that there really weren't two separate submittals in August of 2017. It was just one.
And EE?
This is an email chain between Jean Lynn, the planner, and Dave Caton, and this is actually the one on Friday, October 6th, when the notice of compliance application was attached. Let's see, is it attached? Yes, so it is the last page that's attached is the actual notice of application. So on October 6th, they provided it to us after we had been asking for months. And then it was backdated to August 11th, which was the appropriate date that it should have been deemed complete under the development agreement.
So, during the month of September, after your application was submitted in August, were there any meetings with the city relevant to this plat application?
Not on the plat application. There were meetings with the city. So
And what meetings took place in September?
the one that I know off the top of my head took place was on September 7th. We went in and met with Director Niven and Lucy Sloman and told them that we were going to be submitting site development permits, and we had two that were far enough along that we could explain exactly what they were. One was a retail proposal, which we described as being similar to and complementary of the Grand Ridge Plaza development across the street, and the other one was a medical office building that was closer.
And if we turn to Exhibit C-101 that Mr. Valdez used, can you show us where the medical office building and the retail that you just described would be?
Yes, so the medical office building is located on Block D, so that's the building that you can see, and then there is parking that you can see in sort of a lighter shade that is also on Block D. It includes both a parking structure behind the building that extends to the west over a portion of that lot, and a little bit of surface parking in sort of the southwest corner of that lot. The retail proposal is all of Block A, all of Block B, and the north half of Block C.
And how specific was the discussion that you had about the retail and medical office building on September 7, 2017?
We were primarily asking the city to help us identify what the process was that they were going to require for those, but it was specific enough, particularly with respect to the retail, to know sort of the density or capacity, because we described it as similar to the existing development up there. So does that answer your question?
Okay.
I don't think we talked about size necessarily of the medical office building at that point in time.
Did you talk in September with the city about any of your other SDP applications?
I don't recall for sure. I know we talked about those two.
A question related to this exhibit, which, as I'm your understanding then, would be that even though it's, quote, backdated, I assume the applicant thought that when the application was deemed complete, that was in relation to the full set of materials from August 28th, as opposed to what has sounded like you've been saying was an incomplete set that was submitted earlier. Does that make sense? There's a weird timing here issue where you've said, you know, we tried to submit everything, I believe, on the 1st, and we couldn't do it with the system, and you provided this email, which is Exhibit DD related to that. So then eventually, August 28th, you, the applicant, were able to submit everything electronically. This letter then references a complete application determination related to August 11th.
Which I think that's actually, per the terms of the development agreement, I think it's accurate, because the deemed complete should occur automatically because they didn't ask us for anything else.
Okay.
And so they would have deemed it complete based on whatever was in their system at that point in time. They didn't ask for anything else. we proactively gave them everything else on their checklist after that date.
Okay.
So I still think that the August 11th date is technically the correct date that the application was deemed complete.
Okay.
Does that make sense?
I think,
Because the development agreement is specific on that after 10 days, if they haven't asked and you've submitted application
then
materials.
it defaults to complete.
Yeah.
Okay. And again, to be clear, that even if, without getting into the weeds, but all the sort of concerns over vesting, et cetera, relate to stuff past August 28th anyway. I mean, there was additional documentation the applicant provided on August 28th, and the city's never argued that that documentation doesn't sort of
Right.
factor in on the vesting issue.
Right, I think you are
Okay.
accurate in that. I would add that the December 15th, 2017 submittals that the city is saying are not vested, I have a hard time following that line of thinking, because on the date that those items were submitted, the only regulations that were in place were the development agreement regulations. The replacement regulations had not been enacted yet, and definitely were not effective yet. So I'm not clear how something could have been submitted in December of 2017 and then just not reviewed until they had enacted new regulations, despite all of the requirements in the city code, in the development agreement, and under state law. So I think that argument, you need to look closely at how does that, I mean, I have a problem with partial vesting within a single application, but even if you were to entertain that idea, December 15th, 2017, the development agreement was still effective, and the city still had a duty to follow the development agreement and to process our plat application. So on that date, they could not have told us that they were gonna consider those application materials under a different set of regulations.
I think I understand the argument you're making, but yeah, okay. Just was trying to clarify what that August 11th date meant, and
Yep.
I think we're there. Mr. Lell looks like he had something he needed to say.
Very briefly, I mean, we will be happy to address that for clarification in our rebuttal.
Sure,
It's
I
very similar
assumed
to
as
what
much.
Ms. Lang was saying, and it really dovetails with the automatic effect of a complete application under the development agreement, and whether or what extent there's a need for any sort of written confirmation is a separate issue.
Okay, great. So I think we can move on to what would be FF, is that right? Or you had other questions? I
Well,
apologize.
just one follow-up question. Ms. Heim, the December 15 submittal that you referred to, was it consistent with in depicting the retail and medical office building with the conversation you had with the city on September 7th?
Yes.
Then let's turn to FF. What is this?
So this is an email string between Keith Niven and myself. If you turn back to my original email to him on November 21st, 2017 at 10:21 a.m., we had met with Keith that morning and had discussed vesting of our various applications. I know you've seen this in detail with
I have.
the SDPs, but I think it's important that the plat is also noted on here as vested to appendix, and there's specific reference to section 9.1 of appendix L, so we're definitely working with appendix L at that point in time. And we go back and forth, and ultimately he responds yes to my statement that I'm assuming that you mean the applications are complete and vested to the development agreement as stated in the email below. So this was, again, confirmation that our plat application was vested in November of 2017.
GG.
This is an email from Dave Caton to Jean, the planner, And this was when we uploaded the December 15th supplement. We wanted to make sure that she was aware that it was there and give her a little bit of an explanation. So we also sent it to her via email. I know at previous points, the city has alleged that we didn't properly notify them that we had put something in mybuildingpermit.com, which I don't think we had an obligation to, but we try to work collaboratively, so we had sent this email to our planner.
And I just note that that's K-14, I believe, as well. Just so you're able to know whether you have something or not.
HH.
And this one is an email from Darwin Lee, who works with Mike Swenson at Transpo, and he was sending the February 6, 2018 transportation memo to Doug directly.
This is the memo I have in the
Right.
record somewhere, right?
I think you have the memo. This includes the entire memo with the attachments.
Okay.
Aye.
Aye, aye. All right.
Okay, so this is email exchange between Doug Schlepp and Mike Swenson. So when Darwin had sent the February 6th with the attached memo, Doug's response was, make sure it gets uploaded in mybuildingpermit.com. And so we did that back closer to February 6th. I don't know the exact date. And so on February 17th, Mike sends Doug an email asking him he's checking on the status of the Plat review and if he had any comments on the analysis that we had submitted 11 days earlier. And Doug's response was that he hadn't seen it uploaded yet. So it was unclear to us at that point what happens when we upload materials, since they don't seem to be making it to the reviewer, but we had also sent it to him directly at that.
JJ.
So JJ is actually two letters. If you flip to the third page, there's a March 5th, 2018 letter from our legal counsel at Foster Pepper to Keith Niven and also to Ogden Murphy Wallace as the city attorney. And this was a notice of default under the development agreement. And it goes into great detail into all the ways that the city was defaulting under the agreement, which was in effect at that point in time. I think it's important to note that we did not receive our Plat comments until shortly after this letter came out. So no review happened for, 6+ months essentially, until this letter was sent. And then the March 8th letter to Mr. Schneider from Mr. Niven was one of the city's responses to that to our March 5th letter.
Was there a follow-up meeting to this exchange of letters?
There was a follow-up meeting with the city and their attorney about the notice of defaults, at which they committed to writing a response to some of the allegations in the letter. And so I believe that response letter was the April 4th, 2018 letter that I think is already in the record. As Exhibit G.
KK.
Okay, so Exhibit KK is a staff report on the Westridge North single-family plat. I think that this is significant for several reasons. This preliminary plat for Westridge Single Family North mirrors our application in a lot of ways. The notice of application for both plats actually went out together on December 27th of 2017. The applications were submitted within weeks of each other, I believe, the initial applications. This plat has long since been, the preliminary plat has long since been approved, and I think actually you approved their final plat here recently.
Be out any day now, I think.
Or you're going to approve, maybe approve their final plat. But I think it's important to look at this because both applications were pending at the time the replacement regulations went into effect, and they were treated very differently. The only explanation that we have heard from the city in the context of other hearings is, oops, I guess we made a mistake with respect to Westridge. But when you look at the way that Westridge is treated, it actually is consistent with everything the city was telling us leading up to the termination of the development agreement. It's consistent with the March 2017 letter. It goes through and analyzes the plat under each of the appendices of the development agreement. So I think that point is particularly remarkable when you look at the analysis the city did for their staff, in their staff report for Westridge North Single Family, which was vested to the development agreement, and our plat, which is also vested to the development agreement. Somehow all of the appendices applied to theirs and only some of them applied to ours. All of them were used for analyzing theirs and only some of them were for analyzing ours. Even if you agreed with the city that the process was okay to be different as applied to us versus them, I don't understand how the application of the regulations themselves can be different. The staff report, you can tell they were used, they are based on the same format, except for this doesn't include a vesting determination, whereas ours does. The replacement regulations went into effect in late March, so it was after the date of the staff report, but it was also prior to the date of the UBDC recommendation and definitely prior to the date of the council action. So there's really no reason the analysis should be different in those two documents or for those two plats.
LL.
So this is the recommendation of the UBDC for that Westridge North single-family preliminary plat. This is dated May 4th, 2018, so it was after the replacement regulations were effective. You can see that the whereas statements you know, it says, whereas even though the Issaquah Highlands Development Agreement was terminated on March 28th, 2018, and replacement regulations have been enacted, this application was vested to the now terminated development agreement and was reviewed under those regulations. And it goes on to specifically reference Appendix L processing. So it demonstrates, again, a huge disparity between the way they treated, and they treated Polygon's Western Single Family North Plat and our plat, which were, I mean, in exactly the same point, as far as length of time they had been submitted prior to the replacement regulations being enacted.
MM.
Let's see. So this is an email, this is part of an email chain between Lucy Sloman and myself. The reason why we are offering this particular part of the chain is that the version that the city put into the record did not have all of the attachments that were attached on their August 24th, 2018 response, and specifically those AMMs that Mr. Valdez referenced are attached to this, I believe.
So this is the document that actually includes the AMMs that Mr. Valdez was talking about.
Yes. I know it includes the AM 11-00005. I can't remember off the top of my head what the other one was that he referenced. But it does attach some of the AMMs that need to be in the record. These are the ones that they provided to us in August of 2018.
And so where does this submittal MM in August of 2018, can you relate that for us to Exhibit Z in your chronology?
Yes, so the fifth line down that is in sort of that yellow gold color, where a shelter asked for clarification and basis and waited for city response, this was that first city response. So there is I think there's a document attached. Let's see. A long email. Maybe the document collating the responses is last. Yeah, so the last attachment to it is a document that Lucy was putting together that had our comments and then staff response. The staff response is in italics after our comment or a request for clarification. So you can see that one of the clarifications that we were asking for was, so we had asked for the July 2016 AMM Subcollector 1 standard because that had been referenced in the comments and it was not something that we had, and the AMMs are not something that an applicant can get on its own. Those sort of live with the city. So they had referenced that and we didn't know about it. So when we got that, we thought, well, we better also ask, are there any other AMMs that would change the standards to which you are going to apply to our plat? And then there are a series of other comments that we were looking for clarification on. Number 3, for example, was that they were requesting that we apply both a trail standard and a road standard in a single location. So basically putting the trail section on the road section, so the sidewalk and the trail were combined or adjacent. And we were not clear on where that requirement came from, and it turned out that that actually was not something that was allowed by code. And then we had also asked for some additional clarification about Discovery Drive because we had had a lot of discussions with the city up until the date of those comments that dealt with Discovery Drive, and they had never asked us to do the analysis or build it out in the way that they ultimately asked for in their March 2018 comments.
So going back for a moment to Exhibit Z, you show that the day after Exhibit MM, the ball was back in Shelter's court, and you have 47 days when the process was in the applicant's hand. So what happened during that 47-day period?
So during those 47 days, we were going through the information that we had and really trying to figure out, could we resubmit? We wanted to resubmit and keep everything moving forward, and we eventually got to a point where we realized we really couldn't resubmit without additional clarification. We had already had to wait for so long for that August response that we were hesitant to ask for further clarification if there was any way to avoid it. But we really didn't have enough clarity to move forward, so we ultimately ended up sending the October 10th email asking for additional clarification.
I think this is NN as in no.
So this email is, again, part of the same chain, but this is the December 21st, 2018 response from Lucy to me. After this email and response, we felt like we finally had enough information that we could resubmit. I think one thing that's significant about this one is there's a bunch of preliminary plats attached to this, and I don't recall the details of it, but one of the issues that we had been going back and forth on with the city, and I think you heard Mr. Valdez reference it, was that the city was asking us to put a level of detail on the preliminary plat application that we thought was going too far, which made it particularly surprising to hear today that they're saying that we provided too much detail, because over this period of months, they had been asking us to show dry utilities and all of the, locations of utility vaults and those types of things on the plat, which we were saying that's not appropriate for this level of review, and they kept insisting that it was. And we said, okay, well, can you show us an example of a plat that shows this type of information? They kept sending us SDP applications, which we obviously didn't think were completely analogous to a plat. Ultimately, I think in this correspondence, at some point, they agree that, yes, that can be handled later. So it was surprising after ongoing comments that we needed more detail, that now they're today saying we had too much detail.
So what are the, in a general sense, what are the attachments to Exhibit NN?
I think the attachments, well, there's the collated, the last one is the collated responses that Lucy had been tracking back and forth. The other attachments, I think, are what the city felt were examples of plats that showed that kind of information, but honestly, it's been so long since I've reviewed these that without looking at them in more detail, I can't.
Okay, so again, relating exhibit N, which is an email from Ms. Sloman with attachments dated December 21. Where does that fit into your chronology on exhibit Z?
It would be the 10/11/18 through 12/21/18, waiting for city response to 10/10/18 email request.
Okay, and so the day after you received exhibit N, your chart shows it was Shelter's responsibility to move the application forward at that point, correct?
Yes, at the point that we got this response, then we were moving full speed ahead with our team to try to get the application revised in response to comments and get it back into the city.
And so that period as calculated in exhibit Z is 74 days. What was Shelter and its consultants doing in a general sense during those 74 days?
Revising that plan set that ultimately got submitted in March of 2019, updating any of the technical reports that needed updating based on the comments. So I believe the stormwater report was updated, and I know the transportation supplement was prepared. I don't know off the top of my head what other technical appendices might have been updated at that point, but for sure reviewing the plan set, revising the plan set to be resubmitted.
So exhibit 00, please.
So this exhibit is an email between Ken Shipley, who is at Core and took over for Dave Caton when Dave retired. And this was when Core uploaded the March 2019 submittal, they, rather than uploading the supplemental plat narrative, they actually uploaded the original narrative. And so they had emailed the city and said, hey, can you help us? Because I think you're not allowed to take something out of mybuildingpermit.com. And so he had emailed Jean to say, can you delete that one? And I'm uploading the correct one. She responds back, thanks for letting me know. I'll ask our permit center to delete the original file before routing it for review. But then in the materials that Ms. Sloman provided, she actually included that one that had been identified as being inadvertently uploaded. So it really shouldn't be in the record in that respect. And I think Ms. Sloman provided Ken's email asking for it to be corrected, but she didn't include the response from the city that said it would be corrected.
PP.
This is an email that Ms. Sloman sent to me and to Dave Caton with a letter attached. The letter is dated April 5th, 2019. And this was the first time that she informed us that she intended to process the preliminary plat under the replacement regulations rather than under the development agreement to which it was vested. It is vested. There was a follow-up email from me to Ms. Sloman and then another letter. The other letter, which is dated April 15th, I believe, is included in the record as Exhibit H, but this one I did not see. Is April 5th, 2019 letter, and my email in response to that I did not see in the record, so we thought that should be part of it. Oh, you handed me an extra copy of this one, Pat. So QQ is going to be that email response from me to Ms. Sloman after I received her April 5th letter saying that she was refusing to follow the development agreement. So I wrote back to her pointing out that the city had previously confirmed that our plat is vested to the development agreement and that L requires that the staff issue an administrative recommendation report and establish a hearing date in front of the UBDC. And that the UBDC then makes its recommendation to council, and asked her to confirm that she was going to be following the process and timeframes required under the development agreement since we were vested to that letter. And further, we asked if the city was no longer acknowledging our plat vesting to the development standards in the development agreement, that they issue a final and appealable decision explaining such action. They did not do that. Instead, they issued that letter that is Exhibit H, and I believe, I don't have that one in front of me at the moment, but I believe that one they include a statement that it's not an appealable decision, and so we're stuck with it.
RR.
This is an email chain between Lucy and myself, and I think in her exhibits, there was, so if you look at her exhibit list, K2 has July 26, 2019 Outlook email misdirection. So, and K3 is some email on the High Street Collection Plat. So the way it was explained to us was that Ms. Sloman's email was directing all emails from me into her junk mail, and that she wasn't checking that, and so she thought I wasn't responding to her. She included in the record the emails that she sent to me. She didn't include the emails that I sent to her, so this is the other side of that chain.
SS.
So this is another email chain between Ms. Sloman and me. It includes our comments on the community conference staff report, which we had less than 48 hours to review, but we did provide extensive comments and asked for corrections, which the city basically refused to make. So this is our email outlining what we had asked for and the errors that we had pointed out. There's also email chain on here that just has to do with scheduling and timing related to the community conference.
TT.
Oh, this is just an email that is going out to parties of record related to the community conference memo. And it looks like Ms. Sloman twice emailed the parties of record asking them for comments, which seemed a bit unusual to us.
Mr. Examiner, I think that's all the additional exhibits. I would suggest we take a break and then we'll continue a little bit with this time.
Ms. Sloman?
I received the affidavit of publication
Oh.
that we discussed, and before we closed the record, I just thought I could distribute that while you're collecting bundles of.
Sure. Okay, so I agree, we'll take a break, but right before that, she's just gonna hand out, I gave it a label, I wanna say C something or other. I'll find it.
Oh, right, it
What-
was C6 or something like
Yeah,
that.
this is the the affidavit of notification, affidavit of publication, I think is
Publication,
the term
yeah.
I'm saying, which I had already acknowledged we were gonna be receiving. And I thought I said I would make it C6.
Yeah.
Okay. So then we will take 15 minutes, is that good for everyone? Take 15-minute break, be back at 3:45 to theoretically conclude questions of Ms. Heim. Obviously, we'll give Mr. Lell an opportunity for cross-examination. So let's do it. I'll see everyone in about 15 minutes. Thank you.